Separate property does exist in Arizona, but it's difficult to keep it categorized as separate property. So typically when we're talking about separate property, we're going to be talking about property that you acquired prior to the marriage. So that home that you bought prior to actually marrying your spouse, or that vehicle that you had going into the marriage that was already paid off, or property that you acquired after the marriage. That could be property you acquired even after the date of service in your marriage, so during your divorce case. Or we're going to be talking about property that is not categorized as community property. So one of the exceptions to the community property rule, meaning real property, inheritances, or gifts. Those are how we are going to categorize sole and separate property. It's really important though that you keep that property separate. So if you, for instance, had money in your bank account at the time that you got married, and you choose to take that money that you had at the time you got married and to deposit it into an account with the money you're making during the marriage, and then you're using money out of that account, you're putting money back into that account, we're calling that commingling. And now what you've done is you've taken that sole and separate property and you've reclassified it as community property, meaning you effectively gifted your spouse half of that sole and separate property. So you want to be really careful with your sole and separate property. Make sure that it stays your sole and separate property.